the reason I don't use check forms is because I'm a member of the association and I only use association forms and they're copyright protected. And here's how I've nailed some agents who've interfered with our tenant agreements of yours and listing agreements. Truck could care less about private agreements. They don't have a listing agreement. They don't have a buyer-tenant agreement. And all of a sudden, a buyer comes forward and they have a termination of buyer-tenant agreement, and they want to terminate with you. Well, the minute you see an association form, you know somebody provided that to them. Those are not public forms. Those are private forms that are copyright protected. So we've been able to nail other brokers who've interfered with your agreements because we know they're the only ones that would have given them the form because Trek doesn't have these. And so what we have that we're, did you find that?
Yes, ma'am.
Okay. What we have found is that while Trek approved the forms, TAR adopted them, but Trek also changed, remember how they changed telephone to phone and facsimile to fax? Well, they changed what they call us. Instead of calling us licensees, they now call us license holders. So every form that had licensee had to be changed. And so while we have a very few Trek forms that were changed, we had a lot of association forms that had a licensee in it rather than license holder. So TAR forms will be
What on PowerPoint?
just a PowerPoint, that's all I need. Dot Loop will have those forms probably ready, probably I would think before Christmas. They're mandatory January 1. Thank you. They're mandatory January 1. What does that mean? That means that you could use them now. They're optional for you to use them now with your clients. The one thing I am going to tell you that don't mix and match. Don't use the current contract forms and then use the new amendment because you will have trouble, and I'll go through that. So just remember, be consistent. If you're going to use the current forms, keep it all that way. Now, what if you got an offer on December 25th? Okay, and with the holidays and people being not available to respond and these type of things, you could be looking at maybe not having an executed contract until January 1, right? At that point in time, you and the other agent are going to make a better decision. You're going to make sure they're on the new forms because as of January 1, you cannot execute a contract on an old form. It's called a violation. Anytime you use a repeal form, it's a violation. And the problem is everybody gets excited when they get an offer. And so the listing agent's looking at a form that you're very used to, and they're not thinking, this is not the new form. So again, it's double-sided here. You can't just blame the agent who presented it. You as the listing agent will be responsible as well if you execute a form that is not current. And here's the problem for you. You turn it in, it'll never meet compliance. Ever. Because I can't make an old form new. That was executed, all parties signed it. And we'll bring it to your attention and hopefully you won't do that or you'll be more aware of it. The problem for you is that, we can't go back and have you put it on the new contract. You can't do that because no title company will allow two contracts on the same property by the same parties. That first one would have to be what? Terminated. Or some language, to replace it, and that's when you get into trouble. We had this scenario, the parties agreed that something wasn't done on the rights format. I think they used a 1-to-4 and they were supposed to use a farm and ranch because of mineral interest and other surface rights and other things. And I don't know if the lender brought it to their attention and said, we need to do this, we need to change this. And the parties agreed, the seller released it and was ready to accept another one and the buyers walked away. So again, it's really hard for us to try and change something after the parties have executed and agreed to it. We have been told, truthfully, that the parties can agree to use the form that they feel best fits their situation, but they would never use a repeal form. And that's the situation we're in effective January 1. We've gone through the information about broker services quite a bit, but today what we're going to do is we're going to go through the actual list of forms that have been changed. We're going to go through the 1 to 4 family. When TREC make any revision on the contract forms, it'll be the same on every other contract form, if it's unimproved property or whatever. They're very consistent in that matter, so once we review the changes, you should be able to see those changes reflected in every contract form that you would use. We're going to go through the new third-party financing addendum. The reason we're going to really concentrate on this is because third party has a significant change, and if you're not proficient in it, come January 1, you will be responsible for understanding it, being able to communicate it well to your clients, and all these types of things. And so we'll go through those provisions that you need to be aware of and what they mean so that you can communicate that to your client. The required notifications. Everybody knows that every time in the last few months when I've been through training, I said there are 3 things you would have to do as a buyer's agent if you have a buyer who's using financing on a contract that you would have to bring to their attention. And so I have a handout that is your cheat sheet. And my Christmas wish is that effective January 1, every buyer agent will have those emails uploaded in every folder where they represent a buyer. We are going to know that you did the right thing. We will always know that you explained the time limits to your buyers. So we'll go through that. The list of the TREC and TAR forms that you got, did y'all see those? Mine's blue. These types of things. What you're gonna see on here are quite a few forms. In the middle column, it shows the TREC number. At the very top where it says effective February 1st, disregard the information about broker services. TREC has already approved that, and that is mandatory January 1. And it's been out there, and we've got the template for you to do. The other form that's only effective February 1st is the consumer information form. And that really doesn't affect you. These are forms that TREC is saying have to be posted very clear. In other words, if your client walks in this office, they're going to see the consumer information that the broker is required to post. And so it was sent to all of the owners in the brokerage operation so that they can get some little nice frames at Walmart and put them up on the wall so that it's readily available. And while that doesn't mean very much to you, you do not realize how many requirements TREC places on the broker. We know because we're agents and we're dealing in a transaction what we're required to do, but the broker has a lot of additional issues that they've got to make sure all the notices are proper and everything for them to be in compliance with TREC as well. And so from time to time, it's just nice for you to understand you're not the only one that has to do a bunch of stuff to make sure that everything is done right, that your broker is doing the same. If you went onto the TAR website, you would be able to click on these and see the red line. And the red line version is the current form and the changes. So you would be able to see it. Today, what I did, they didn't color them, but if you ask for them, somebody can send them to you through the system. I highlighted them in red, okay? I'm not red, yellow. I'm seeing red still. Yellow. And what that does is it kind of helps you see that this is what's new. That kind of thing. So Karen has all the copies of them, and I'm sure they wouldn't mind sending them out so that you could even download them and have them on your system, and they would be highlighted in yellow, the various changes that were reflected. So what we're going to do is go through the 1 to 4 family needs. First thing we're going to do is start with paragraph 3. Pretty simple, right? Y'all have to remember to do something. Because we have changed the contract and removed paragraph 4 financing, what they did is in paragraph 3, we still have to put the finance amount or the loan amount, but we have to mark a box. We have to tell them, is this a third-party financing addendum? Is this a loan assumption? Or is this seller finance? Okay? And so what the seller has to know is that while those addendums may be attached, they should be attached to the contract in paragraph 22. The seller needs to know, is this third party, is it loan assumption, or is it seller financing? Now, how many of you have done loan assumptions? I'm seeing I have 3 in the last 2 weeks, which is more than I've seen in almost 10 years. And that kind of tells you that something is changing. Most of these wonderful low interest mortgages that everybody's been able to get, they were assumable. And you're thinking, how could they be assumable? What if the interest rates go back up? I qualified for a 17.5% mortgage interest rate in the 80s. Pretty crazy. 17.5%. I mean, I can't even fathom that. I'd still be living in that house paying on it. I'll be married 44 years Friday. So, I mean, I can't even fathom that. So what you want to make sure is that in the event you do have loan assumption, as a buyer's agent, you're going to know that the form does look different than third party. The buyer still has to be approved and qualified, but there's just a whole different scenario that is involved when you're assuming someone else's loan. The next one is,
What would you check for a cash purchase?
there would be no check for cash.
So you
3B
just
would be
wouldn't check.
blank.
Okay.
Down payment is the same and sales price is the same. So again, they're going to pay all cash, that'll be in 3A. Now, on seller financing addendum, we'll see that addendum only when the seller owns the property free and clear. Everybody understand that?
Yes.
There is no such thing as a wraparound or contract for deed. We don't get involved in those. They are high risk, and I've had the claims adjusters for these insurance companies tell me that if you did that and facilitated that type of transaction, you're going to have no coverage. They're a huge risk. We don't do them. There are only a few, and the interesting part, I used to have a list of real estate attorneys that did them, and I love the title company's attorneys. Oh, sure, we do them. Oh, yeah, right. We were sued because the attorney didn't do it right on 2 of them. So I know that it's not easy to do them. And the part of it is the way that the escalation clauses are on existing mortgages and other things, that type of thing. I only have one attorney that I get to turn to now in the state. The other one that I used quite a bit, he says, I won't touch them anymore. He said they've just gotten too complicated, and he said, I don't want, there's too much risk. When an attorney says that, you run. Okay.
So is it now seller financing or seller financing?
Seller financing can only be done when the seller owns the property free and clear. A contract for deed or a wraparound is not that. That's not when a seller owns it and can convey it. Okay. Now the next paragraph is paragraph 4. When they remove financing, and they move financing onto an addendum, they had all this room. So they said, I'm going to add a new paragraph. The interesting part of this paragraph is that it should have always been in the contract. It is a requirement of law that you and I, if we have a transaction where we are the principal, where we're purchasing or we're selling, or we represent someone that we're related to, or we represent a trust, or we could be a beneficiary or a business entity, all of these things had to be disclosed in writing prior to an offer so that the other party would know that. So they have this paragraph, and I'm going to read it to you because it is a great deal more than just what we talk about being related to, which some of the statute is. It says, Texas law requires a real estate license holder who is a party to a transaction or acting on behalf of a spouse, a parent, a child, a business entity in which the license holder owns more than 10%, or a trust for which the license holder acts as a trustee, or which the license holder or the license holder's spouse, parent, child is a beneficiary, to notify the other party in writing before entering into a contract for sale. At this point, this would be where we normally put in special provisions, but you would say buyer agent is related to buyer, listing agent is related to seller. So-and-so is an owner in the XYZ entity. Whatever disclosure needs to be done. Don't go into a lot of detail here. You don't have to give any detail. If the other party's just real curious, you just can say, there will be no comment on that, okay? But the issue comes down to anytime you represent a party where you could be a potential beneficiary to anything, you have to disclose. Now, in my book, I think truthfully, even if you're best friends with somebody, we have an agent who does a lot of business with her ex-husband, and she always puts in there, buyer agent, was married to buyer, is the next spouse of the buyer, that kind of thing. And the reason is, if it ever became an issue, the other party's gonna say, well, if I'd known that, I never would have made an offer on it, or I know, you know what I'm saying? They come up with all these excuses of why they never would have done something. And you can diffuse that when you're proactive. Again, don't give a lot of details, just state your relationship. When I represented my friends and they bought houses and sold at listed houses, I would put a listing agent is friends with seller. And one agent told me 2 weeks ago, he says, Marilyn, I'm friends with all my buyers and sellers. I said, not really. I said, you're a professional in the transaction. You can become friends afterwards, but you're not just going to all your friends. He said, no, they become my friends. I said, well, I understand them becoming your friends, but while you're in the transaction, you will be professional. That's what we are, professionals. I'm going to tell you that some of my best friends came from walking in the office and wanting to know about the properties in Bernie. And it's funny because it's almost 20-something years ago. But I kept it very professional while we were in the transaction, and then once we closed and funded, we could be friends. But again, I do believe that being truthful about your disclosure of your any relationship, I think is very important, because people kind of weight it based upon when they find out about it. Yes.
So your line there is if someone you had a relationship with prior to the contract, then you should disclose that.
I would think so. I would think so. One of the agents that was interested in the class at Metropolitan, she said that during the course of the contract, prior to the offer and the negotiations, the listing agent never mentioned that they were part owners in the builder's company, and it was a new construction. And she said the buyer decided to terminate during their option period, but they found out that he had a financial interest in that building. I said, no, that should have been, not saying that anything would have been different, but they should have been told that from the very beginning. So again, just remember that we have a brand new paragraph, and that's where we get to add it. They're getting to the point where Trent doesn't want you to write anything in the special provision. So what they saw regularly being written, and they've accommodated for it in 2 of the instances.
How about having the same last name? Would that take the same last name?
Well, when we do compliance,
What am I even?
Right.
Probably, and then it happens to me, I'm like, oh my gosh, I forgot.
yeah, when we do compliance, if we see something obvious where they go, we'll ask the agent, are you related to the buyers or sellers? Because until that point in time, we don't know. And so we'll ask a lot of times. And what happens is the agent goes, yes, is there a problem? I put it on MLS. I said, well, MLS is not a part of the contract. You have to put it in writing where the parties could acknowledge it, and that would go, now it's in special provisions, but like paragraph 4. Yes.
So Marilyn, it's just a relationship, family relationship needs to be disclosed, and a financial?
I personally, any relationship and any financial interest would be disclosed.
Okay, but I forgot, I missed what you said about friends. If you're friends with the person beforehand, you have to put friends?
I do, absolutely. I disclose all relationships. I'm not gonna have anything pop up and have it become a problem. No. So again, I deal from the premise of being, there's nothing that's concealment of that does no good, it only does harm. There's nothing that's gonna hurt you when you say, I'm friends with the buyer, or I'm related to the buyers or friends. Yes? She's asking a question. She says, what if we've already executed a contract? In here it talks about the blood relationship. that you are required by law to disclose. I'm gonna tell you that I have found it to be true, that we displace all disclosures. If you're representing your cousin, they should have known that from the very beginning. Because they're always gonna put more emphasis that you did that because you were related to them or something else. So again, it's been the law that we have, they clarified it about the interest of 10% and those other areas. If the broker becomes intermediary on a transaction, you are required to complete at the very bottom any relationship you have with them and business relationship. A lot of the agents who represent investors, one of them, she says, I represent this investor for over 15 years in multiple transactions. They require that when the broker becomes an intermediary because they know that that could have such an impact. And the broker remains neutral. The parties still continue at a fiduciary level, but all the relationships have to be disclosed in writing on the notice of intermediary. Yes, ma'am.
If the agent on a transaction and you're working with the listing agent, and the listing agent has a broker and fails to disclose that they have a broker and they are not the broker on the form, is it on the mistake of the agent on the other side to catch that? Or, I guess, whose due diligence is it to make sure that the other agent is a listing agent or a broker, etc.?
Well, you would know that if they advertise in MLS, it shows up.
Right.
Yeah, and then it's reflected in page 9.
Okay, there you go.
That's what you would do. Now, I am going to tell you, you want to be very careful about when you receive an offer. Okay, we had an instance twice in the last 2 months where, and it was intermediary, where one of the agents who presented the offer license was inactive. They had completed their classes, you know, but they paid it, but they hadn't completed their classes. And the agent in the office, none of that agent. Or do you think they're going to track to see their status? No. They did when somebody else said, oh, their license is not active. That becomes very, very problematic for you because you never want your seller to accept something, you know, and especially when it's the broker's an intermediary. We've had a lot of cases where they went out on HAR to check it. Please don't use HAR website. They don't update their website like Trek does. Okay, so just remember that. Don't rely upon HAR. You're going to check it on the Trek website. If they are inactive, you're going to say, you know, my seller is in possession of your offer. They're very interested in responding. I cannot communicate with you about real estate, and so we're going to contact your broker and see who they're going to appoint to take over. You can have no conversations with anybody who's inactive. None. Okay. So just remember that you'll have to do that.
Question about that. Could you contact the seller?
No.
Wouldn't they in some ways?
No, the broker owns the listing. You can never, ever go over a broker. You have to, you can't cross the sign in the front yard and go directly to the sellers. When there is a broker listing, the broker is the listing.
So it would just be.
Yeah, he or she will appoint another agent to take over. You'll do an amendment. And put in paragraph. Okay, the next paragraph that has a change is paragraph 8, 688. It's at the top of page 2. And prior to the word being, will be amended to read, they added a preposition, or. So that was the only change in that paragraph. Okay? Very minor change on something like that. The next paragraph change was what we call, notice, I keep hearing somebody talking. Okay. Notice of water level fluctuations. It's on page 3, paragraph 10. Okay, that was added, and the part of that being added is paragraph 6 is all about notices. The sellers are required by law to provide all these notices in writing to a prospective purchaser. And instead of us having to write all these things in or advise our sellers, oh, you need to do this, they place them in the contract, what is required by law for the seller to communicate. They added water fluctuations when they endorsed it, and that made it a part of the law in June. and it was effective September 1st. And the scary part was, because Trek didn't modify the contract, they came out and told us, we give you permission to add this to special provisions. So between September and when Trek came out with the new contracts, if we had a property where the seller had this type of issue, we would have had to add something in special provisions for the seller to comply with the law. Nobody reads this paragraph at all. How many of you have read it to your buyers? Nobody's read it. And the problem is, if a buyer doesn't acknowledge the notices, if a buyer initialed this at the bottom and didn't read it, and then found out about something later, they're accepting these notices. They can do their due diligence during their option period or whatever, if it affects the property and they're thinking, I don't know if this will be an issue for me, if I'm gonna like this. But make no mistake, the moment they initial it, they have accepted it. So you just make sure that you're not gonna bypass that paragraph 6, that you're really gonna review it with them and let them know. There are very few fill in the blanks on it, and that's typically why nobody pays attention to it. They kind of overlook that. But the notice of water fluctuations, this is about properties that abut to a body of water that is over 5,000 acres and feet. And what happens on these types of things is, it's pretty obvious when you go to the listing, you're gonna know if they have a lake in their backyard. It comes right up, it's gonna be pretty obvious. What happened and why this is in our contracts now and required by law is there were some developers who developed these beautiful communities that had these beautiful lake-type things with fountains going, and some of the lots, the lake was in their backyard. It looked like it was an extension. And when we had the drought, there was a third-party company that the developer allowed to drain that beautiful lake that gave their property some value, perception or whatever, and water the golf course. So what happened is the lawsuits ensued where the developer failed to bring to the attention of a purchaser, you can have that lake up by your yard, but one day it could be dry. And they didn't give them that notice, and that's why it was enacted into law, because they wanted to know. And last week I had an attorney join us for some of these trainings, and it was so funny because, when you have an attorney in the room, they always have so different than 6 years ago when we had the drought. But they say that, he says, there are these areas that have these fluctuations where the property owners are great and they've got water and the value of their land just plummets after that. So they just have to know that there could be that possibility. So again, it was because somebody had failed to bring it to the prospective purchaser's attention. That's a lot of what paragraph 6 is about. The next paragraph is paragraph 7. Now, paragraph 7 is why most agents get sued. You get sued because of the property condition. What amazes me is that I don't know of any realtors that lived in these homes before they listed them or sold. But everybody thinks you have this psychic or cognitive ability to know this has an inherent defect or flaw. And so what happens is that, we get sued because they didn't know about the condition of this, or they didn't know about termites and all these types of things. In paragraph 7, 7A in particular, the seller is giving permission to the buyer to bring in those inspectors that are licensed by Trek or authorized by license to inspect the property. Well, they've added the provision that any hydrostatic testing must be separately authorized by seller in writing. And we are working with the attorney. I captured him. We were in a car together for over 7 hours. And I pulled out a list and said, okay, I have all these questions I want to answer, kind of, as he was driving. But We're working on a form, and I'll tell you the problem I have. Think of it this way. You represent the buyer or the seller, correct? Yeah. If you are a buyer's agent and a buyer has a truck inspector that says you need to have a hydrostatic test performed, at that point in time, the buyer can't just say, I'm gonna do it. It's the seller's home, and it's not an inspection. It is an invasive test and can cause damage. At that point, you have to reduce it in the form of an amendment. And you say, well, I'm in the option period, we're not out of it yet. It doesn't matter. That's the easiest way for us to right now get the seller's permission in writing to allow the hydrostatic test conducted. If you are a buyer, the seller could come back and say, well, as long as you're going to be liable for any damage. Well, a buyer's going to say, I'm not going to be liable. Thank you, I'll terminate. I'll go on to another property. As a listing agent, you're never going to tell the seller, yes, I recommend that you do the hydrostatic test. You're going to tell them, I do not recommend you authorizing this. You need to do your own due diligence. Call your friendly plumber, Fred, that's helped you for years. Visit with Fred to see if Fred would do it or how that test is and what will happen to it and what could be for the potential downside. You're never going to say it's okay to do it, because the moment you do, you're going to personally be responsible. And that's what happened when everybody kind of just said, oh, sure, go ahead and do it. We found out that the listing agent didn't even know what it was. But she told her seller, sure, no problem, we'll do that. I don't ever recommend that you do that, because that'll put you in a liability position. I am going to tell you what the hydrostatic test is, for those of you. How many of you know what a hydrostatic test is? Okay. What happens is, for instance, if I were a buyer's agent and I showed a property and the buyer's kind of interested in it, we got the seller's disclosure and the other disclosures, and in it says previous foundation repair, and in section 3 behind it will say transferable warranty, blah, blah, blah. As a buyer's agent, you're going to tell the buyer, look, I'm going to tell you, I'm going to ask the listing agent for a copy of the hydrostatic test that the sellers performed when the foundation work was completed. You're not saying do a hydrostatic test. You're asking for the seller to provide that to your buyer. And there's a good reason why. If they did not go through a structural engineer, because the structural engineer says you must have a hydrostatic test afterwards to make sure when they did the adjustments that there was no pipes that were cracked or that. The structural engineer has it. Plus, the structural engineer also says that you would not only need the hydrostatic test, but you need me to come back out after the foundation company does the foundation work to make sure it was done properly. Okay? And so you, as a buyer's agent, know that these are things you need to ask the listing agent for, so your buyer has a better understanding before they make an offer that this could be an issue for them. Because you have to get permission from the seller in writing to allow the hydrostatic test. I have notations that they're saying that the seller's going to hold harmless and they want the buyer to be responsible. So now all of a sudden we're getting all these different little hold harmless that are provided by the attorneys for various brokerage firms, that the seller's either going to blame the buyer and make the buyer responsible for any damage, or the same way that the listing agent is worried that if the seller does agree to it, the seller could come back on the listing agent and say, you told me it was okay to do this. We've had several issues because the pipes, while the camera, typically the way they normally find out if there's any cracks, they do a camera, and a camera goes down. But unfortunately, the camera test is not conclusive. And once that camera test doesn't come back 100%, no, there are no cracks, the next step would be the hydrostatic test. And the hydrostatic test is pretty 100% if there are cracks or not. The problem is there can be extreme damage caused with that pressure going in. Where it could have been a little hairline fracture, it could become bigger. Okay, so sellers have that liability issue. Yes?
So is this only done if, like, would you only ask for hydrostatic test if you see like the seller's disclosure that they've had work done on the foundation, or should you ask for this on every?
No, I think she's asking, would you ask for a hydrostatic test report from the sellers on every? No, once you have reason to believe that, hey, it's been brought to our attention, they did previous foundation work, I want to see the transferable warranty, the hydrostatic test, the structural engineering report, because your buyer's going to need all of that to make a really good decision about if they want to go forward with an offer, all that type of thing. It's not you interpreting any of this, it's just knowing to ask verification of it. And yes.
So if foundation work has been done on a house, really, for it to be, a perfect scenario, that hydrostatic test should have been done after that foundation work was done? I mean, to prove, it's more like to prove that everything's fine now?
Yeah, and as I said, all the structural engineering reports I reviewed, they all advise to do that. So if I know that there has been structural foundation repair and no structural engineer has been involved, I'm going to be very concerned with my buyer. That's what you need to know. What's interesting is this last session that we had, one of the broker associates, he says, "You ready for this, Marilyn?" He said, the seller put on the disclosure, they had previous foundation work and they had done a hydrostatic test. They put all this on the seller's disclosure. And the buyer was represented by their mom, who is a realtor. And they said, well, what do you want done? And the buyer said, I want another hydrostatic test. Okay. Now this agent was representing the buyer of the transaction, but their mom's a realtor. And so their mom was telling them what they need to do. So he goes back to the listing agent. He says the buyer would like, on the amendment, would like a hydrostatic test done. And the listing agent came back and said, oh, that's crazy. The seller's already done that, blah, blah, blah. Well, the buyer told the agent, said, well, just tell him I'm walking. I'm going to terminate it now through the option because I'm not going to do this. So the seller said, oh, okay, I don't want you to go away. It was done, and there were lots of cracks.
Seriously?
They didn't disclose it.
Well, they had a hydrostatic test that said everything was clear at that time. The interesting part is, once the cracks were found, the seller, they had negotiated, the seller had to replace all of them and fix all those pipes, and he did all of that. And then the buyer says, I'm going to send that same person, that hydrostatic specialist, back out. I'm going to have him tested and make sure that the repairs the seller did were good. That's part of this process that has to be handled. You see the difference? You just don't rely upon somebody else's word. You make sure that they verify. And then when they found the damage and the seller said, okay, I'll fix it, and then the seller says, it's done, we fixed all of it, the buyer just didn't take their word. They sent that person back out. So see, that's really that cycle that has to be done anytime we negotiate condition of property. We're never going to take their word that it was done. The buyer's really going to verify it. And the reason for this is because the contracts now, as they were changed in 2014, and what they'll still say, is that this transaction is as is. And what that means is only if the buyer has been told everything that the seller knows and no concealment of information. There is no as-is when the seller conceals something, because the buyer can't make the decision to accept it. They would only accept it as is when they knew everything, okay? So just remember, while we may have a receipt from XYZ HVAC company that has a license number, do we know if they did the right thing? No, that's why we send the inspector back out, and he's now going to see did they do it based upon what the agreed upon amendment was. It's not real simple. And for new agents, it is truly learning the methodology the methodology of how this gets facilitated in a very short period of time. These contracts don't go on forever. We'd like them to go on like a week, but they're 40 days typically, or 45 days. So remember, that's part of it, is learning how to manage that methodology that has to be used by every buyer. If they negotiate, they're going to have somebody verify. Okay, they're just not going to say, oh, okay, they did it. And don't you ever stand over something and say, the seller did it. It's fixed. Because you don't know that, even though you might have a receipt for it. So again, paragraph 7, very important part, use the amendment, I think that's the best way, but be on the lookout. I'm working with this attorney to try and find something where my interest is to protect you. Your interest is to protect your sellers or your buyers, to be in their best interest. My biggest issue is if you are representing a buyer or if you represent the seller, I don't want either one of those parties to point to you and say you're responsible for any damage based upon any hydrostatic test or any mold test. And so we're trying to work an agreement that they would all acknowledge that they allow something to happen, but that they're not going to hold you responsible for the testament. And so we hate to create more paper, but I am real concerned about this because I don't know if you're going to tell the seller, I never agreed that you should do a hydrostatic test. And I'm afraid that as a buyer's agent, you might not bring to their attention once an inspector says they need one, that you don't explain how important it is that they do this, even if the seller won't pay for it. Because a lot of the dispute comes over the price. Seller says, you can do it, but I won't pay for it, then you're responsible for everything. So again, it's a little more complex than just them adding that one sentence into paragraph 7A. Yes, sir?
Yes, I just wanted to mention Mary, that the reason why you're talking about this is because it's something new. We didn't see this before on the previous contract.
Oh, no. There's because there's been lots of lawsuits.
And the other part is you're doing a great job because what you're trying to do is protecting us and protect the company. So by making us informed about how that process goes.
Well, if I protect you, do I protect your clients? Yeah, see, that's what's the best part of this. I know what it's like in production when somebody looks to you and they've never bought a house and they want you to be a magician and, you know, wave your magic wand and make everything perfect. I know how that feels. And my thing is, as long as you have recommended, disclosed, discussed, and you've got it in writing somewhere, they can make any decision they want, and they're just going to have to live with it. I just want you to make sure that you have done all the steps necessary to inform them. In my opinion, this is what I would recommend. The inspector said it, and I agree with the inspector. Now we'll have to figure out how to facilitate it. But I'm going to tell you, a lot of backlash is going to come when the seller who has a company who's got an attorney who's wrote stuff and said, oh yeah, you can do it, but then y'all are all responsible if there's any damage. So I want you to be real careful about that scenario as it comes up. Now the next paragraph we're going to talk about is for paragraph 14. But before we get to 14, I want you to look at paragraph 9 closing. Okay. Paragraph 9 of the contract closing. Did y'all get a contract? No. Okay, well, y'all everybody knows that they remember it perfectly. Okay. Here's what I'm going to tell you about paragraph 9. It says, both parties on or before this date are going to close and funds be happy. Well, Track proposed that there was going to be this clause added, and I talked to you about it in August, and it says that in the event RESPA mandated 3-day ruling starts over, the parties can extend the closing date up to 10 days. Well, I didn't like that at all, because I felt that that's kind of like, we're going to take the full 10 days even though it's not necessary. You know what I'm saying? And really, if they do the 3-day mandated, it's 3 days plus the extra day to close. So that would be 4 days at the most. And true, we don't count Sundays and holidays, but you know, for the most part, 10 days, that was an extension of a lot of time, and I felt there was going to be abuse of it. I think people were just going to ask for that full 10 days and not think of, can we do this before the 10 days? And so what Trek's ruling was, is they said, after all the block sites and everything, they removed that provision from the proposal, and they did not include it. So we're still not seeing anything about the TILA RESPA mandated changes. We're not. We're all the way up to paragraph 9, and we're not doing it. What Trek determined was they didn't need to add that language because the buyer and seller really, this is their contract, and those two parties alone need to determine if they will grant an extension and for how long. Now, I am going to tell you, it's still rules for your sellers. If it's mandated and the loan won't close unless it's mandated, your seller most likely wouldn't mind extending the closing date for 4 days. What I don't like is, well, we'll extend it to this date, but we just don't know. That's not a good way for a seller to make a decision to grant an extension. They really kind of need to know what's going to happen, how long is it going to take. Closing date is one of those. The paragraph is very clear. It says that everybody's going to close on that date, or at least on or before that date. And the party that doesn't, they're going to be held in default. Default is different than termination. Termination means that a party is going to exercise a provision that they have to tell the seller, I'm going to terminate this contract and I get my earnest money back. Default means they don't have any provision to get their money back, and they could have a provision that they could be sued. And there's a big difference, and a lot of times our language, what we say, we'll say, oh, you get to terminate. Well, terminate sounds like they have a right to be able to do that, and that's not the case. We have a lot of situations where we've got, I don't know why, but we had 5 sellers in the last few months who decided they didn't want to sell their property. Can sellers do that? No, not for the contract. I mean, they can make that decision, but they'd be in default of the contract. And it's very damaging and costly to a seller to breach the contract, because they have lots of expenses that aren't on the contract. The broker gets their commission immediately when the seller has breached it. And so there are lots of issues. There's just a lot of problems for a seller. That's why sellers really need to get in front of an attorney, a real estate attorney, to give them good advice. It's interesting, out of all of those, only one seller decided not to close. The other sellers all talked with their attorneys and showed up for closing because they found out how bad that was going to be. The only one who didn't is there was a family crisis that occurred on the seller side, and the buyer was willing to get reimbursed for their inspection and appraisal and other things to be made whole so that they could go to another property. Yes?
Is there any protection for a seller if they're in the middle of a contract and then realize they don't want to sell?
No. A seller can never terminate the contract. There's no provision. They'll be in default every time. Even when it's something that's dramatic or deadly, like that. There's just, no seller has a provision. That's why once they put their initials and signature on it, we're really scared for them. You can terminate a listing agreement. We're talking about a contract. Okay, paragraph 14 is casualty loss. Does everybody know what a casualty loss is? Most of the time when we talk about casualty loss, you think, oh, they lost the roof, we had a wind tornado, a flood. In other words, we think it's almost catastrophic. And that is not the case.
Hold on, Ms. Merrill, I apologize, we're just trying to get, make sure everybody has what you need.
Trying to follow along.
No, it's the number that.
Two, I believe it's page 2, Keller.
Is it correct? Is that true?
Yeah, page 2 was this.
It's all right. We're still missing paragraph 9.
Okay, so everybody needs page 5?
Page 2 and 5.
2 and 5.
We're still missing page 2 and 5. We apologize, guys.
All right, just.
Thanks. Are you done with page 2 and 5, Ms. Marilyn? Are you done with page 2 and 5?
Yes, I'm on page 6.
Okay, so then at this point, what they have is fine. Yeah, okay. All right, guys. I promise you this will never happen again.
That's okay, I gotta tell you a really funny story. For our broker, I did the training, I guess it was last week, I don't know, these days, I can't believe we're halfway through December, right? Anyway, they had about, it was close to 100 agents in the room. You know, they've got that big huge thing just like you do, and it was really funny. I I asked my gentleman who helps me set everything up, and I said, Norman, I said, where are all the handouts? He says, oh, no. We sent them to all the agents, and we told them you either print them out or bring them on your laptop.
Oh, no.
Out of that whole room, 2 people had them printed out. There were a few on the laptop, but for the most part, they were all looking at me like, and I only paraphrase this because it takes up a godzillion slides for me to try and duplicate what you might have. But it was really interesting. He says, no, we're treating them all as adults. I said, just don't leap off that, building right now. Let's just work into that after we get through these changes.
Okay, so we're good though, at this point, everything we should have, you already got into it, okay. Thank you, okay.
Okay, but casualty laws, what we're talking about was something that was really obvious that it just took, it was just massive on the property. Casualty laws could be like this. On the day of closing, the buyer agent told the buyer, we need to go through and do a final walkthrough before we go to close. Is that a good thing?
Yes.
Oh, yes. Because when they got in the house and they walked in, they heard splash. And they walked down and there was water. And what had happened is evidently something came loose under the kitchen sink and the water came through. Of course, you know how when you move and the movers come in and they do things and nobody goes back and checks anything? Well, apparently that's happened and they moved out, I think, the day before. But whatever it was, they had to call the claims adjuster out to make a claim, and the closing had to be extended. And what was interesting on that premise was there is, when you have water damage and it has been for any length of time, they never could get a finite about when this happened, but based on the seller's reaction, they were pretty freaked by it. So it probably had been just in the last day or two. And so what happened is the claim adjuster came out and gave their definitive, said it needed to be tested and all these other things and remediated and all these things fixed. Well, they were willing to give the proceeds for this claim to the seller. Well, in the homeowner's contract, the sellers told the insurance company, I'm going to make these repairs. You give me that money, that's what I'm using it for. Otherwise, it's fraud. So they had to add in paragraph 14 that it says that extend the time for performance up to 15 days and the closing date will be extended as necessary, or C, accept the property in its damaged condition with an assignment of insurance proceeds if permitted by seller's insurance carrier. So now the proceeds are just not going to automatically be given to or cost to be fixed by giving those proceeds. The insurance company would have to have their letterhead stating that they were aware that the proceeds were going to be assigned. And that way the seller isn't going to be involved in committing fraud. Okay. Now, once the lender finds out about that, they want those proceeds in their name and the buyer's name. Because guess what? They want to make sure it's done because they're not going to give a loan on something that needs to be done. And I'm going to tell you, we deal with a lot of things. That's why we never hide any amendments from the lenders. The lenders have to know the condition of the property better than almost we do. Because otherwise, we could negotiate to facilitate something, and all of a sudden, it's going to turn out that it'll be a very bad scenario for a buyer. Case in point, last week an agent called me, and she said, oh, Marilyn, I sold this house in August. And she said, we had all those rains, and they had the rains that came in, and she said they called their insurance company, and their insurance company denied it because it was pre-existing. I said, now, well, tell me the rest of the story. She says, okay, well, during the inspection, the inspector said that it needs a new roof and told a lot of bad things. So they got a roofer out there, got an estimate for a new roof. They negotiated all of that, got the seller to give monies towards the buyer's closing and as a credit and all this type of thing. They knew all of that. The problem was when she got the call from this buyer, she said, oh, you got that money from the seller, didn't you replace the roof? Because their claim to their insurance company was fraud. They knew at the time of closing. And I asked the agent point blank, I said, did you have an amendment about these repairs and the new roof? She said, well, we had an amendment that showed the concessions the seller gave from negotiations for it. It didn't say anything about roof being replaced. I said, I am going to tell you next time, lender would never have closed on that loan. That would have been a lender-required repair. And I said, when was the appraisal done? I'm surprised the appraiser missed that, if it was that bad. She said, well, I think the appraisal, she says, you know, we were, before the trip thing, she said, I think the appraisal was done very close to the end type of thing. Well, you see, the issue I had is I was very concerned because the buyer was coming back on the buyer agent saying, I want the seller to pay for $15,000 more. Well, they'd already negotiated that before they closed and funded. First off, they said they were waiting until their home in Abilene sold, and they wanted a metal roof instead of the composition roof. And they needed the money from the sale of their existing property in Abilene to pay for that. Well, that doesn't take into account you're responsible. Once that buyer was aware, in writing from their inspection, from the roofing company's estimate, from negotiating with the seller, they don't have anybody to go back on. The fact that they keep coming back to this buyer agent torturing her is making her feel like they're gonna hold me responsible. I said, well, good luck on that one, as long as you didn't conceal anything. She says, but you know, I am gonna tell you something. That's the part that, you know, gives you a little pause. She said, the roofer that I called out to give the estimate, I said, oh, you chose the roofer? You met the roofer? She said, well, the wife is still back in Abilene. I hear all the stories, but that was my big issue. The roofer gave the estimate, didn't put on their estimate the condition of the bracing and the trusses and the bad, real bad part of the roof. He says it to the agent right before he's leaving to get into his truck. He says, gosh, this is really bad. Those braces are really bad and all this. So I said, why did he put that on his estimate? Why did he rely upon you now, having to put that in writing? So it doesn't look like you concealed something that was told you by the roofer that those buyers would have had to know. She said, I did tell them. I didn't put it in writing, but I did tell them. I said, well, you all know what that means when you don't have it in writing. She said, yes. I can say something, they can say, no, she didn't. I said, that causes me a little issue. Okay. The part about being the one to arrange for the roofer and get out there and do that, you notice how this agent, she's very helpful, and she told me, she says, Marilyn, she said, these kids are like my kids' age. She said, I felt like I was being a little mother hen. I said, oh, I understand that. I said, but you understand that you're arranging for the roofer of your choice to give the estimate, then the roofer telling you things that they didn't put on that report, puts you in a bigger situation for liability. That's all I want you to be aware of. You're never going to change the way you work, and I understand that. You just might have to take a little bit more time and put something right. So the roofer didn't say this on the report, but I'm going to tell you right before he got in his truck, this is what he told me. I said, the same thing you said to them, you should put it in an email on something like that. And I'm going to tell you, the moment somebody says they need a new roof, you're probably going to get several roofers out to give estimates, not just one. Don't you think? I think so, because you have quite a few good roofing companies here, and one roofing company would find maybe the braces were rotted and need to be replaced. That's what that $15,000 is that the buyers are coming after the buyer agent for. They want the money for the braces. And so, and I'm thinking, well, at the point in time, I said, this is bad for your buyers. They have no ability to go back on the seller or the listing agent at all. So the only one you're looking at is the buyer agent. And that's why you have to have everything in writing to prove that. But casualty loss is not just what you're thinking, like a roof blown off or big flooding. It can be something as small as having a leak under the sink that went unnoticed and then they found it several days later. Typically, that happens with the HVAC when it overflows and nobody's in the property. And that can happen, that overflow for several days, and then all of a sudden somebody finds it and you don't know when it started and that. But, you know, they make a lot of issue about the auxiliary damage to it and everything like that. So you just want to make sure that on the casualty loss, it's fine as long as the seller has gotten the insurance company's approval. And that's as a listing agent, that's what you want to have in your possession. Yes?
Oh, no.
Okay. the next one that we had to change on is paragraph 18D, and it's at the top of page 7. Now, the current form had a little formula that was very easy for us and the buyer and seller to know that if I wrongfully withhold the release of earnest money, which we had talked about how earnest money gets released and all this, and sometimes one party doesn't want to release it. We had a really nice little thing. It said we get the earnest money, 3 times the earnest money, our legal, reasonable attorney fees, and our court costs. Well, in Harris County, this was challenged. A seller demanded the earnest money because the buyer defaulted on the last day of closing. They weren't individually approved and they wanted their money back. And the seller says, you don't have the ability to get your earnest money back. And the buyer says, but I want it. So the seller says, well, then we're going to go to court. And that's what the seller did. They had rights under the contract. What happened was the judge who ruled on this said that the contract was unenforceable and overly burdensome, this clause was. So the moment that ruling happened, Trek had to change it because they can't give us forms that are unenforceable. That's the reason we have these forms, so they're enforceable legal contracts. So what's kind of interesting about this, I'm sure in their infinite wisdom, the attorneys on the Broker Lawyer Committee and the Trek attorneys all thought, every attorney's favorite word is damages. So now it reads that any party wrongfully fails or refuses to sign a release acceptable to the escrow agent within 7 days of receipt. That means you send in the release of earnest money and notice of buyer's termination to the title company, and you send it over at the same time to the listing agent. The clock starts ticking. Once that escrow agent has it for 7 days and nobody's releasing it, the seller, the non-defaulting party, the one who won't release it, gets number 1, damages, the earnest money, reasonable attorney fees, and all costs of suit. Again, damages. So what happens? The seller has damages of $120, say. And the attorney representing the seller says, oh, it's not $120, it's $12,000. So that's how attorneys look at damages. There may be this nefarious little invoice for what the real damages are, but oh, that's not the real damages. We're going to make it $12,000. So they just made it really disastrous. What I am going to say is that this is what you really have to tell your buyers and sellers about withholding release when they're not the party that should be demanding it. This is more deadly than what we had in the contract before. Because again, damages are very different. For instance, we've had sellers who, bless their hearts, moved out. They made their home ready. They went to closing, and then the buyer found out that they were not individually approved, which horrifies me to think on the day of closing, the buyer gave notice to their apartment, they have to move. You know, all these things is horrible. So what happened on this, the seller, when they sent over all of their damages in their invoices, it was way more than 3 times the earnest money and earnest money. Way more. And so what happened was, you know, this was a perfect example. Sometimes that 3 times the earnest money and the earnest money didn't take care of all of the damages that a party sustains. That's why when we do these contracts, because of that element of that TRID revision of the Telerespa 3-day mandate thing, we kind of don't know when a seller could vacate. Even though we have a closing date, they're subject to what could be mandated. So just be mindful that maybe the best way for a listing agent to negotiate for their seller at time of offer is to attach a seller's temporary residential lease. That way, the seller won't be doing anything that will eventually get them caused to have damages in the event the buyer doesn't get approved or doesn't go forward. And again, we've always had that situation. There's just more of an element of the timing not being strictly adhered to because of this other mandated 3-day rule that can come into play. So just remember to be careful about that. Now in the next one, if you look at paragraph 22, they changed the third-party financing addendum for credit approval to third-party financing addendum. They changed the name, because it's no longer just individual approval. It's also the finance for the property from the contract that's gonna go on third party. The next thing is paragraph 23. It says, notices under this paragraph must be given by 5 p.m. local time where the property is located by the date specified. In other words, all dates in the contract expire at 11:59 p.m., but not this one. This one expires at 5 p.m. And as I said earlier, this was always written in special provisions, and Trek sees all that and they go, oh, I don't like these agents writing things in, we'll just change it. And most of the blogs were from brokers and agents who said that they were professionals, and that to have negotiations going in such extended times in the evening caused more liability issues if we fail to remember everything really well because we're tired and we're trying to do this and we're pressured in the parties and all this. So they entered 5 p.m. Now I'm going to tell you what happened. We had somebody who used the current contract, which says what? Doesn't say 5 p.m. the current contract, right? So they needed to extend the option period. The buyer needed to pay the seller more money so that they could extend the option period. So he went into the forms and he grabbed the Trek amendment. Notice the Trek has changed. They're up there. They've got the new forms. He didn't realize that it said that it expires at 5 p.m. Yeah, I know. You know the rest is coming. So what happened was, he's working under the premise that they have until 11:59 on the last day of the option. And his buyers got home, they were in traffic. Well, I understand they're in Houston. They were in traffic and they got home and they said, you know, I think this is really what blah, 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 this type of thing. And he tries to present it to the listing agent. And she said, oh, that's too bad. The seller realized that at 5 p.m. today, the contract stood as written between the parties. At that point, as a buyer's agent, you just want to cry. Because now you've got a seller who is not going to negotiate. They're going to think that I'm going to force this buyer to go forward when they don't realize the contract has a lot of other provisions that they probably can terminate. But anyway, that was very unfortunate. So what my advice to you is only use the current forms, every current form. In other words, don't mix and match. If you're using the new forms for Trek, use all of them. Don't mix and match, because that was unbelievable penalty for the buyer's agent. Yes?
You said everything else expired right before midnight except for the option. This is the only thing that expired.
All dates in the contract expire at 11:59 unless otherwise stated, and this one does state otherwise. And it means 5 p.m. right where the property is. Doesn't mean 5 p.m. on the East Coast, doesn't mean 5 p.m. on the West Coast, you know what I'm saying? They had to put that in there because local time where the property is located, because they knew everybody was going to ask that. Well, I'm on the East Coast, when is 5 p.m.? That kind of thing. So just remember, it's where the property is. Anytime you see things in parentheses, it's usually their way of saying, y'all are so silly, you're never going to figure this out, I'm just going to tell you. And that's what they do. They did that paragraph 7 to us several years ago, and it's still there. They won't remove it because they are upset that people do not understand that the option gives them the unrestricted right to terminate, and that is a provision that they get to exercise. And what they mean by as is means, I've been told everything by the seller, I can accept it right now as is. That doesn't mean that the condition won't change once they get an inspection report. We have a lot of people who fail to mark that in paragraph 7, and Trek just says you have to mark one of them. You either accept it as is, or you're going to do 7D2 and say the following things will be done to the property. Now, if you look at the last page of the contract, does everybody have page 9? Okay. Here's what changed. They're asking for your brokerage firm license number. They are asking for your license number. And they are asking for your supervisor's license number. And the reason they're doing that is if somebody gets upset with you and wants wants to file a complaint, it's very easy for them to put your license number in and pull up all your details so they can make the complaint process much easier. Because nobody needs your license number unless they want to file a complaint against you. Okay? And if you know, the information about broker services has dramatically changed. You can't give it out blank anymore. You have to have it totally filled in with everything perfectly before you ask the buyers or sellers to initial and date. Okay, so just remember that. They're systematically saying we want to be able to have any consumer go after you and do it quickly. Doesn't that make Merry Christmas? Now, the next thing we're going to go through is the third-party financing addendum. And before we do that, we're going to do the email checklist. Does everybody have that one? This is the one where I made you turn your paper over last week. Oh, why did y'all do that again? Flip your paper over, flip the form over, and on the back of the form, I want you to write the 3 things that you as a buyer's agent must put in an email to your buyer prior to the number of days expiring in third party. 3 things. I should see 3 things. Everybody write. Everybody write. No discussing this. This is not like you get to talk to about this. This is 3 things. I've been hounding this since August with you people, so I know you know. Number 1. What's number 1? Number 1 is, did they get the terms? The type of financing, when they mark that box, they get the terms. So number 1, did you get the terms? That's on the addendum. Number 2, somebody said, are you individually approved? Yes. Are you individually approved? And number 3, do you need more time from the seller to be approved? 3 things that you have to have. They don't believe you had a conversation about it. They do believe the time limits is your duty to explain it to the buyers. They do believe that a buyer can't look at the contract and addendum and pluck things from it and know what to do with it. They know they can't do that. They don't know the use of the form. You're the one who knows about time limits, and that's your job. So now on this email checklist, this is everybody's going to have this effective January 1. You can give me an early Christmas present if you do it now. Number 1, the first email. It'll be sent to your buyer and the lender at the same time. It's going to say, congratulations on your contract. For the contract and the third-party financing addendum, you have until. When you use the time limits, you put in the number of days, the executed date, and it gives you a date for the notice that a buyer would have to give a seller in writing. To notify the seller in writing if you're not approved or did not get the terms as stated on the addendum or would like to request additional time for approval. Right there in that first email that you send, you've covered all 3 components that TREC says you must cover. Okay? Now, the next email will be sent approximately, I would say, about 3 business days before those number of days pass. Make sure that y'all use a calendar when you present an offer. No option period should expire on a Saturday, Sunday, or a holiday. And no number of days for third parties should ever pass on a Saturday, Sunday, or holiday. We want to be able to make sure that we've got enough days that if the seller needs to be notified, we've done it so we can get their response. And it says, send this email out about 3 business days to the number of days passing a third-party financing addendum. Our time limit in the third-party financing addendum will be up in 3 days. Please contact me regarding the status of your individual approval, the terms you will receive, or if you need additional time for approval. It says, if you do not contact me and the number of days passes in the third-party addendum, you will lose your earnest money if you are not individually approved. That was the other sanction that the agents got because they failed to tell the buyer, if you go past those number of days and are not individually approved, you will lose your earnest money. And there's an aversion. Agents do not like to talk about losing their earnest money. You just won't do it, but you're going to have to do it. Okay? Because TREC, as I said, got after all these agents. They all lost, every last one of them. Some of them got serious fines, and some of them had permanent records on track, that they were negligent and incompetent in reviewing and bringing the time limits to the attention of their buyers. So again, my gift to you is that we're not gonna have this happen anymore. This is just something real simple y'all can do. If you wanna say, hey Joe, glad to see you yesterday, whatever you wanna doll it up, but the content of it's gonna be basically the same, okay? We wanna make sure those points are given to them. It says, please respond to this email no later than, I would say no later than noon tomorrow. If it's 3 days before, you need to know by noon. Because in the event, the status update, you can determine if you want to terminate and ask the seller for more time for approval. Seller's not obligated to agree. They need to know that too. Or proceed forward and risk losing your earnest money. That's what we need them to know in writing. And that's what your job is as the buyer's agent. Yes?
The number of days is referring to paragraph B1 in the
Yes.
financing addendum.
Right, that's a number of days in third party. Okay. Now, what we're gonna do is we're gonna go through the new third party financing addendum. Everybody has that? Okay. There are lots of similarities between the third party financing addendum and credit approval, but this new addendum says this is not just about credit approval, this is about property approval too. This would not be attached to the contract if there were a cash transaction, okay? Cash purchasers don't have the luxury of getting the property approved. There is no third party to say it has to approve, right? So cash purchasers would need to, in their option period, when they would have the unrestricted right to terminate, they need to find out if the property has met value. So they would need to do their appraisal during their option. Because otherwise, a buyer would be in default if they said, hey, it didn't appraise, and the seller says, good luck on negotiating. I agree to this sales price and I'm sticking with it. Your buyer would be in default if they didn't go forward, and that is deadly. Because what we have found out is that sellers read the contract, they saw how much was in paragraph 3A, that's all cash. So the sellers now know, I can go after them for money. It's no secret, folks. When you're a cash transaction, you either have the cash or you don't. And if you default as a cash purchaser, the sellers have a big incentive to go after you because they know you have the money. It's not like an FHA purchaser, those kinds of things. So that have limited money down and stuff like that. It's obvious already to the sellers that we've got somebody who has the money. Now, third-party financing addendum paragraph A is the type of financing and the duty that the agent must tell the buyer, you have a duty to obtain approval. And you have to work very hard at it. The best way for our buyers to do that is to, ahead of getting a property that they want to purchase and put an offer on, is they're going to already get all this done and take it to the lender and visit with them and get all of that taken care of. And that way, all the lender has to wait for is the executed contract for them to start getting all the process completed and put in the notification for appraisal. Now, the interesting part is on 3B, the type of when it says the financing amount. It had a box for seller financing addendum, loan assumption, and third party. If you look down at the bottom, they have reverse mortgage. And effective January 1, TREC will repeal the reverse mortgage addendum. Because they created one for reverse mortgages a couple of years ago. And so they will repeal it. They added it on third party, so we no longer will have a reverse mortgage addendum. How many of you have done reverse mortgages? Keep it that way. It is one of those types of transactions. Even my team, and I'm related to my team. Everybody who I know and is related to me works with me. And so we have these discussions, and it's really funny. One of them will say, I understand a seller having a reverse mortgage and then wanting to sell the property. I said, yeah, that usually results in short sales. One of the parties deceases and somebody's got to liquidate the property. and that type of thing. They said, I just cannot get my head wrapped around a buyer using reverse mortgage. And it's so funny because we'll have all these discussions, and I said, that's why I tell the agents not to do them. Because we spend way too much time in our meeting about something that you're never gonna do, you know. The only thing I am gonna advise you, if you have a buyer or purchaser who wants to do that, they better have the best lender who is so proficient in this, that they're gonna hold their hand, explain it all, because you're not gonna be able to. Okay, it's a very complex financing methodology, and that's not what we're used to, okay? We understand conventional, we understand FHA to VA. Now, if you look at conventional Texas vet loans, FHA, VA, USDA, and reverse mortgage, just remember that if they do a Texas vet loan, Texas vet says, I give you this interest rate for this many years, but they're not the ones that guarantee and underwrite the loan. VA typically is. So there would be 2 boxes if you did the Texas vet loans. How many of you have done those loans? Yeah. In my part of the world, everybody who's ever served in any military did their stint in San Antonio, and when they went to exit, they all came to Texas so they could be Texas vets, because one day, and they can exit the service and be a Texas vet. And there are tremendous benefits. So just remember, next time you work with a vet, find out if they're a Texas vet, because we've had an interest rate less than 2% this year. You can think about that, that's awesome. Okay, on page 2 is where we're going to see some changes. Paragraph A talked about the type of financing and the duty that the buyer has to obtain it. Paragraph B is the approval of financing. There's 2 prongs to approval, the individual and the property. And before, individual is just the third party, and the property sat over in paragraph 41. And so Trek said, well, let's put it all together on one form. It would be better. So here's what we have in paragraph B. B1 says buyer approval, again, individual. There's 2 boxes. They're either going to need to be approved, they're subject to being approved, or the other paragraph says this contract is not subject to buyer obtaining buyer approval. Okay, so it's the same box that we had in paragraph 4 of the contract in the event that they're not subject to approval. Have y'all ever had buyers who are not subject to approval?
Yeah.
Yeah.
That's right.
Yeah, they're already ready to go. They've been approved. All they need is the property. Okay? And so this contract would have no contingency if paragraph B1, the second box, was marked. There would be no contingency for individual approval because the buyer doesn't need individual approval. They already have it. Paragraph 2, property approval, this has changed. It says, in paragraph 1, buyer approval, besides marking that box, you have to fill in the number of days. Do not miss that. In the preliminary form that they sent us, they had that fill in the blank box at the second page, and we told them we didn't like that. So they reformatted it so that it wasn't that way. Remember how they had part of it down below? It's dangerous to have a little fill in the blank. So those number of days will be converted when you use your time limits Excel spreadsheet. It will give you a date, and that's that date that we referenced on that email about this is when your final approval notice, or the final notice that you get to give the seller about your approval or the terms on the loan that you selected. The property approval is something that hangs over everybody's head the whole time until the property is approved. Whereas before, the buyer being approved, the buyer just has a contingency to tell the seller, look, I'm not approved or I didn't get the terms. It's not about the buyer's final approval, because we know that's not possible. They don't get final approval till the very end. So you don't want to misinform a buyer who you're saying, this protects you in the event you're not individually approved. That kind of sounds like that's a global protection until the end of the contract, and that is not the case. The approval individually is only gonna be, do I know if I'm individually approved, or do I know I didn't get those terms? And now the buyer gets to say to the seller, I'm providing you notice within those number of days. It is not about the buyer being finally approved or anything, it's just those two elements. The one thing I am gonna tell you is it doesn't require a lender to validate the buyer having the right to provide notice to seller that I didn't get those terms or I'm not individually approved. So make sure your sellers understand that when you explain it to them. They don't need a lender saying, you're not approved. They're never gonna be approved at this point. Because it happens very close to the closing that they get final individual approval. So just remember, sellers need to understand that there's no lender letter that's gonna come validating what a buyer provided as a notice of termination. Yes?
Would you have some advice on when you represent a buyer and they do not get individually approved and we provide that notice to the seller's agent and the seller's agent thinks we need a lender letter? At that point, how do you have that conversation with the listing agent?
It's really hard. We had big discussions the last training about how do you explain to a buyer agent that this is not carte blanche to final approval, it's just a small contingency the buyer has. In that instance, what you're going to say is, well, the buyer has instructed me to respond this way. The buyer absolutely knows their provision in this addendum. It doesn't say that a lender has to provide the decline. It says, I get to notify the seller within these number of days. I have done so. If the seller wrongfully withholds a release, I am going to exercise my provision in paragraph 18D of the contract. Period. That's how you handle it, very contractually, very pointing to every provision that that buyer has. Okay? It does not say above that the buyer had to get a letter from the lender to decline. Now, property approval is going to be different. It says, property approval will be deemed to have been obtained when the property has satisfied lender's underwriting requirements for the loan, including but not limited to appraisal, insurability, and lender-required repairs. If property approval is not obtained, buyer may terminate this contract by giving notice to seller before closing, and the earnest money will be refunded to buyer. This provision does require the only party that can decline property approval is the lender. And here's the situation. We've got a buyer who puts a lot of money down. Say they put $250,000 down on a $500,000 home. That lender is going to say, oh, I don't care if the property appraises or not, I'm going to give them one. Their risk is such that they say, hey, I don't care that it didn't appraise. The buyer thinks very differently about that. I don't want to buy this property if it doesn't appraise, or I want the seller to come down. Unfortunately, they have no provision. They can try to negotiate with the seller, and the seller may negotiate, but bottom line, that lender is the one that has to decline the property, not the buyer saying, I don't like it that it didn't appraise. There is a formal declination letter that all lenders can use, and that they mark the boxes, and it's on their letterhead, and that is their providing that notice. We have a lot of them who, buyers and sellers who both say, I'm not going to release because I don't believe that. Well, we know in our hearts who defaulted. Make no mistake, we know every provision of the contract. I can tell you on every transaction who defaulted and who didn't. All of you can. We know that. The problem is sometimes we have parties that we represent that lose their reasonableness when something triggers like this. And they say, well, it's just a matter of principle. I'm not going to release it. How dare they keep my property off the market for 25 days? How dare you as a listing agent ever let me give them 25 days for individual approval? All these kind of things ensue. The problem you want to do is identify to the parties that paragraph 18D is very, very deadly to the party that withholds a release. That's what your job would be at that point, because you're not going to be able to communicate reasonably with them because they're upset or mad about something, okay? But I do want you to bring it to their attention, if they don't sign that release within 7 days, there are legal provisions per the contract that the non-defaulting party can come after them for. Yes?
Is a title company allowed to open title on a property that hasn't closed out the earnest money from a previous contract on that property?
I've only had one title company in the last 23 years that I'm aware that has ever done that. Every other title company will not open title and have two contracts for the same property with different parties. Okay, I've only seen one. And the reason they did it is because there was no earnest money on the second contract.
Oh, very smart.
Here's what it was, how it was used. They went back to the same title company where the first contract. They hired this attorney. The sellers were going after the buyer for defaulting, and they wanted their earnest money. The buyer said, "I'm entitled. I served in the military, and you're going to give me everything I want." And he dug in his heels. And the seller says no. So he hired an attorney. The attorney advised on the second contract that there be no earnest money. And it was taken to the same title company. The attorney worked feverishly with the seller, trying to get the other first buyer to release the earnest money to the seller and all of this. And the buyer knew that they could really strong arm the seller because they knew they had another contract. And at the time of closing on the second contract, the first document the seller signed was the release of earnest money going back to the buyer. That's the only time I have ever seen that happen. Now, we did have a truck complaint, and the listing agent got slammed by a truck. And what happened is the listing agent advised the sellers to, on the second contract they got, because they had a dispute on the earnest money release. On the second contract, she advised them, she said, "Let's go to another title company, because this other title company won't let us do this." So they took it to another title company, it closed and funded, and when the first buyers found out that it closed and funded, they filed TREC complaints, civil lawsuit, and TAR complaints against the agent. She lost all of it. The listing agent went down on that. And so, because that's not our job, our job is not to help parties, avoid doing the right thing. Our job is to facilitate. And I'll be real honest, I wish the agent had just advised the sellers, you need to have a real estate attorney step in and guide us. That's all they had to ask for. And the real estate attorney would have taken care of that element. Instead, the listing agent got nailed. Okay? Ask me, how many years do you think they've been in the business? Less than 20?
35 years?
More than 20 years, yeah, almost 30 years. What's interesting is we find that agents, the statistics show that agents 7 years or less aren't the ones that have bad problems and issues and trouble and lawsuits. It's agents who've been practicing for 7 years or more. They kind of think they know everything. And in our queue for compliance, one of my people contacted me and says, "Oh my God, I don't know where they had this contract form, but it's from 2010. I said, "Well, it had 4 revisions since then." They said, "Where would they have had that?" I said, "Well, I don't know where they had it, but it wasn't on any of our web portals and stuff." So you have to kind of think of it. They just pulled that old form from somewhere. So when you're going to go and clean house before January 1, you're going to get rid of every little form that's going to be replaced, and you're going to shred it, put it in the fireplace, whatever, but get rid of them. I don't want you to have them all in your possession. Now, time is of the essence on these 2 paragraphs, and you said, "But Marilyn, third party says that if those number of days pass, they no longer have the provision for individual approval." Well, that's true, that part just goes away, but the property approval remains. Okay? Again, the lender gets to determine that. The other one, the buyer has the provision to tell the seller. Now, the next paragraph that you actually have to complete would be paragraph D. And that would only come into play if you had a purchaser doing FHA or VA financing. By federal law, they're protected. They can never ever be forced to buy a property that doesn't appraise. Okay? Now, what goes in that first fill in the blank and the only fill in the blank in paragraph D?
The loan amount.
Thank you. Yes, sales price. Don't put loan amount. It would be wrong. So sales price, we're always trying to hit value. Value is sales price on that, so just remember that. Yes,
The price they're buying it for.
The
not
sales
the
price.
they're listing for.
correct.
And that's why we're seeing more of these listings that take conventional financing and cash financing inside.
And you know why they're doing that? That's a good point. What happens, we have a seller who's listed their property, they got an FHA purchaser that came onto the property. The property didn't appraise. FHA purchaser had the terms to terminate, get the earnest money back. Now the seller cannot advertise in MLS that this contract could be accepted at FHA unless the seller reduced the list price to the appraised value. Yeah, because that's the problem, it's there for 180 days. You know how long that is? 6 months. It sounds less with 180 days. No, not to my knowledge. Yeah, and so just remember that if you have a seller, they're gonna have to understand that they're gonna have to sit around and wait for different kinds of purchasers because there cannot be an FHA purchaser come onto this property because they want more than the appraised value from that FHA appraisal. Did somebody?
Yes, so on the conventional, because we're trying to negotiate on the appraisal, if the house has an appraisal conventional, there's no provision that says that we have to lower the price to the appraisal. So is that a technique that realtors do to kind of negotiate the price down to the appraisal?
Well, most of the time, I don't like it in special provisions where they added a time of offer. That's scary because it conflicts with the contract and we already know we're gonna be in a battle in court. But the moment a buyer is notified by the lender, look, the property didn't appraise, the first thing the buyer is going to do on conventional financing, the lender is going to decline it. So the buyer has that protection that they can terminate, get their earnest money back if the seller won't negotiate. The problem for the buyer is that they can never force the seller to do anything. So the seller would have to agree to it. If the seller doesn't agree to it, the lender terminates, gives them permission to terminate because the property didn't meet approval and the buyer goes away. The one thing I am going to caution you about, we have some instances where the purchaser said, well, if it doesn't appraise, I'll make up the difference, okay? And because they really wanted the house. You could never get an amendment with the buyer saying they would make up the difference or bring that to closing without the lender having approved them doing that. We had a situation where the parties agreed to split it. It was $2,500 each. The parties agreed to it. The lender came back and said the ratios were all thrown out of whack by the terms of the agreement. Now the buyer no longer has individual approval. They lost their earnest money. Yeah. And the buyer agent was horrified because they weren't thinking that this could risk that poor buyer having a provision to get their earnest money back.
So check with the lender first.
Oh,
before
yeah.
you talk
That
to the
lender
seller.
will have to approve any monies that the buyer brings. Now, if the buyer has a lot of assets and income and all this, it's usually not a problem. But in FHA purchases and VA, sometimes VA, but mostly in FHA, when you have somebody with marginal assets and reserves, the lender has to look at that. Those reserves all have to be there, and they have to make sure that this money to make up the difference hasn't compromised their loan ratios, okay? And that was so sad because nobody expected that. They thought 2,500. I am going to tell you how that one got resolved. The buyer didn't ask, nor did the seller. So I want you to understand that. The two agents got together and they split the difference for the buyer. And it was a pretty, as I said, nobody asked them. Those agents on their own came up with that when they found out that the buyer would lose their earnest money. They felt badly about the way things have been negotiated. They both learned a lot, both of the agents. They knew now that they would never ever do that without the lender saying it was good, but they felt that they should have known that. They really took the high road on that because the other few that I've had right before that, nothing was done. The buyer was held in default because they had negotiated. But those two agents felt that they should have known more that would not have resulted in this. And you know, that's when you really are glad to cooperate with agents like that. You find that happens a lot with Keller Williams agents, and I know I'm partial, but I have a lot of experience with a lot of other brokers and agents in this area with disputes, and I know exactly how they act. And it's so refreshing when they'll work together to make something happen in the best interest of both of their clients. The seller got the closing he wanted, and the buyer got the property that they wanted because of that. The paragraph E, now this is what's changed. Right before the current form that we use for third-party financing addendum for credit approval, right above where the buyer and seller sign, it says that, hey, the buyer authorizes buyer's lender to seller or buyer or third representatives information relating to the status of the approval for the financing, okay? Now, what happened, and this is the first place that you see a hint of it, is instead of using the TAR Tiller RESPA authorization form that gives the buyer or seller gives permission to share that information with the agent and broker, they've added this paragraph. It says, seller and buyer authorize buyer's lender, title company, and escrow agent to disclose and furnish a copy of the closing disclosures provided in relation to the closing of the sale to the parties' respective brokers and sales agents identified on the last page of the contract. So if you have a transaction coordinator, they're not on the last paragraph of the contract. They would have to see different authorizations. So just want you to be aware of it. This is very clear what it says, that the agents have to be on page 9. So if you use transaction coordinator, assistant, something like that, they won't have access nor permission to touch or view anything. That would have to come separately in that Tiller RESPA authorization form. But for the most part, we're going to be able to have the provision done in the forms rather than having an additional form. Now, how many of you, have you experienced where the lenders would not release the closing disclosures to the buyer's agents? We have had that. And here's what I just want you to understand from the lender perspective what they're doing. It's not that they want to be mean. Even when the buyers said, yeah, share that with my buyer agent. There is a Privacy Act, a federal requirement by Privacy Act, okay? This other provision came under the Tiller RESPA mandated closing disclosure rules that came as a result of the Dodd-Frank Act. Well, here's the problem for the lenders. The lenders are afraid, even with the buyer's authorization, that if the lenders share that information with the buyer agent, they could have provisions under the Privacy Act that could come back and bite them. So don't be so upset with them. They're just not certain of the act, the Privacy Act's implications in respect to the closing disclosures. The Consumer Financial Protection Bureau and all of the TRID mandate, all that is covered, but not in conflict, could be a provision for the Privacy Act. And that's what lenders have to be very careful with. And we wouldn't know about it unless they had the truth in lending part on the closing disclosures. Have some of you experienced where the title company presents a modified version to you that looks really like the old HUD one for you to review, rather than all of the truth in lending side? And so it's been really nice because some title companies have really found a way to provide you the information you probably need to verify contractually, any credits or anything that the buyer or seller said, but not have to be privileged to the confidential information and the private information of the borrower. Okay, so that's a real good positive.
So Marilyn, are you saying it depends on the lender and the title company if they provide that to the
It'll
buyer's
be the
agent
lender,
now?
not the title company, it's the
So the lender,
lender.
so some will and some will not.
Right, we've already experienced that some lenders won't. Most of the banks won't do it at all. And they're the only ones that I've had agents call me and say, you know, they want, I said, well, here's what you do. I recommend it that you visit with the buyer when they get their closing disclosures. Look over their shoulder, just look at it at that time. It goes back to them and you go on your way and you don't have any confidential information in your possession. There are always ways for us to do it. And I'll be real honest, I've been a realtor since 1993. I presented offers at 11 o'clock at night. Our business was very different. When we got an offer, our duty was to present that to the seller. We didn't have, the seller didn't have a fax machine or whatever, we didn't have scanners, they weren't using, we got in our little cars and we drove all the way over to their house. And I go to bed at 7 o'clock sometimes. So can you imagine how bad I was at that hour of the night? I usually brought my teenager who was driver's permit and said, would you like to practice driving? And he would go and wait in the poor people when I go in the house. They say, is your son really in the car? I said, oh yeah, he's listening. He's got his Walkman. Colin's 36 years old now. So anyway, but it is interesting because we conducted business face to face. I didn't have to worry about a digital signature. I had the John Henry right there in wet ink, and we would, before we put it in our little scanner, we didn't have a scanner in our copy machine. So here's what happens. Fast forward with the convenience of expediting, people giving us signatures who are over in Europe or Asia, wherever they are in the world, and thinking that you would have really had to be in front of them, holding the paper out in triplicate form so you could leave where they had a copy. Think about it. The resistance I get a lot of times is agents aren't even thinking they have to get in the car and go do that. They just can't even fathom that. So just get back to basics. If we have a lot of agents who said, the people I represent don't do email. Well, I know that. I loved that I had a specialty that I didn't even realize. I practiced in it, and that before I went to South Africa. My husband took me away from life and everything, and I got to spend 4 glorious years in another part of the world. But when I came back, Gary Keller said, Marilyn, you get that sphere of influence working on you, and get back into real estate. And everybody had died. I got some real nice notes from the children of God, and they said, we really appreciate that you helped our mom and dad move from their house they love so much. And I'm thinking, this is getting depressing. I said, I'm going to get out of real estate. I know that. But I loved working with individuals that needed a lot of time. They needed me to explain 5 times what this meant, not 1 time. And so, everybody has their specialty that now there's a designation for that. I could have a designation. But again, most of the time they didn't have fax machines. They couldn't, have ever facilitated anything via email. So just remember, sometimes we have to stop and do it the way that makes most sense rather than facilitating the way electronically that we've kind of come used to doing the transactions on that, I guess.
So when those disclosures come to the buyers, can they copy us? Can they send it to us kind of help them see, or is it not?
You can do that. The only caveat that I have for you as an agent is the moment you accept it into your desktop, your server, wherever, you got it. And somebody could steal it, and then you personally will be responsible. See, that's why I don't want the agents. You see the difference? That's why I've been saying it's not that you can't have access to it if they give you permission. I'm just concerned about your liability if somebody hacked in and got that information. You know what I'm saying? And so there's better ways to do that. I had clients who would say, Marilyn, I want to show you my financials. And I was going, no, I'm the realtor. I'm the one who gets to show you house. No, Marilyn, I really want to tell you. And these would be people that just wanted me to know how much they had so that they could buy the property. And it was funny because the more you tell somebody, don't show that to me, I don't need to know that. I just need to know what your comfort level is, what your threshold is, or what you want to see. And so I was very much hesitant for people sharing their confidential information because that is very personal, and I just don't want that. It wouldn't make any difference. When they told me and their lender told me they're good to go, I trusted them. That's what I should be able to do.
Yeah, but like in the hot one and trying to kind of help them see numbers.
No. And I'm with you, that's why if there was a way that you could be there rather than hold on to it or have it in your possession, I would love that better for you. It's not that you can't do that, it's just a risk you
And
personally
I
take.
suggest him to go with an accountant, because like my clients are out of the state. So they're going to be out of the state by the moment they close, so it's going to be remote closing. And so they have no idea how to see a HUD one.
You have great risk with not explaining that document to them.
Maybe can explain in another HUD one, that way they can kind of see what they're looking for.
Or you could go to the escrow officer and be there at the title company and say, I'm at the title company now, they've shared with me the closing disclosures, now we're gonna go through them. And then leave them with the title company, and you leave, okay? You have to review everything on that HUD one with your buyers. Director will come after you. You can do it by phone and just follow up in an email, thank you for spending 7 hours with me on the phone reviewing all this. You know, whatever it takes so that it confirms you actually did what you did.
Okay, but I don't have to have that copy on my email.
No, see, that's my thing. Yep. And, because we've had, in this year alone, we've had, title companies who were hijacked and they came in through the listing agent systems and diverted, wiring instructions. Oh, yeah, we've already had lots of incidents, that's why I'm saying, that's what scared me.
Take care of that.
I know. That's what I was afraid, you know, y'all, your first instinct, oh yeah, I got a copy of this, and the next thing you know, you're gonna call me, like the agent did last week, and he says, Marilyn, my laptop was stolen. I said, please don't tell me you had any lease applications or anything. He said, no, I use the portals just like you said, I don't have any information on either social security or anything. And I felt much better, because I didn't like the fact that his laptop was stolen, but at least I knew he didn't have to go crazy trying to notify everybody, I'm gonna have to pay for, you know, somebody to pay attention to your credit for the next 5 years. So you have to be careful about that. Now again, I just wanna reiterate, yes,
Did I hear you say the appraisal should be done during the option period now?
for cash purchaser, absolutely.
Just the cash?
Yeah,
Okay.
a cash purchaser, because they don't have a provision if it doesn't, you know, they have no negotiation power. Appraisals are usually done now, they're ordered the moment they have an executed contract. I'm seeing appraisals come in right after the option, almost every time. And here's what happens, the buyer and seller negotiated the condition of the property on an amendment. Option was waived, they went forward. 2 days later, they get back from the lender required repairs. I'm seeing more lender required repairs, I haven't seen them in 10 years like this. We're seeing them with very big frequency. So, just what I said in the beginning, what is happening here is the result of them being a little skittish. These lenders are concerned because they don't know what's gonna happen. So they're being overly cautious. Some lenders are saying, we're gonna get 3 appraisals. They keep pushing it back and pushing it back, making sure that every rock is turned over so that a buyer is not mistreated. Because that's their big thing, is making sure the consumer is protected. So again, you have to be very careful, because what I'm seeing is the appraisers are very afraid. The group of appraisers told me, look, Marilyn, if I call the listing agent and say, I want to appraise the property, I want to do it tomorrow at 2 o'clock, and the listing agent starts talking about value and that it needs to appraise, blah, 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 all this kind of stuff. He says, I have to alert and close the file down. It's expensive. And they have to be turned in to the review board. And the review board is going to say, based on what that agent did the agent interfere in the appraisal process? And so we've already had several agents go through a review board. And so what you have to be careful about is that if the appraiser calls you and they say, I'm going to do the appraisal, do you have any comps you want to share with me? And you're going to go, oh yes, if you ask for comps, I do have comps. And oh, by the way, I have a list of amenities and upgrades that the sellers have done over the years they've lived there. Would you like that too? If the appraiser says no on the amenities, you're just going to share your comps with them. But if the appraiser says, sure, send them to me, you're not going to put anything in the email other than, based upon our conversation, you requested these items, I am providing them. Thank you and have a great day. Okay? You understand, you're just gonna be very cordial. If they don't say, I don't want that, don't give it to them. You don't push it, because you could be subject to the appraisers being skittish and reporting it. There's great liability for the appraisers if they don't tell about an agent interfering. And here's the worst part for you. If you are deemed to have interfered, any fine they come back and place on you, you personally will have to pay. There is no E&O coverage for any violations administrative. None. That's why I've been telling you over the course of the last few months not to press that with the appraiser. Answer questions when asked, but don't get into any discussion about value, because that could be where you could be caught in that element. The attorneys who've written a paper so that I can distribute it said to me that for the most part, brokers and agents in this consumer financial protection environment will not be subject to these fines and punitive areas. Those are mostly for the lender or for any third-party provider that has violated. They said, but in that instance where you come into play, like with appraisers, that could be the element. Yes?
My question would be, if you get a call from an appraiser to tell you when they're gonna be going out to a property and getting access information, am I allowed to tell them, yes, Tuesday at noon is great, it's on Supra, and I've left a copy of the CMA on the counter if you would like it?
Yeah, that's
You
fine.
can say that?
Yeah, you're not pushing it.
Okay.
You're just saying on the kitchen counter. And what the agents have all done, they've all left everything on the kitchen counter. Because that would be that the appraiser can either choose to look at it or not. It's not like you forced it on them. And that's a fine type of thing.
Okay.
And as I said, when they call them at the appointment and get to talking and say, you know, I have a list of amenities, can I provide that to you? And if they say no, then you're not gonna do it. You're gonna let your seller know this too, because traditionally, listing agents, that was your job. And I met the appraiser at the house every time, because I learned a great deal from how they appraise. And so, you know, I was real quiet, sitting over in another corner, just waiting for them to say I'm done. And you know how, as a listing agent, you hold your breath because you're thinking, they either like the red brick or they don't. And we had one appraiser who felt in the hill country that red brick was the kiss of death. And he did not appraise well. And we knew this. And if you had a listing and it was red brick, you know, at first you felt like painting it real quickly before they come. But those days are gone. Appraisers aren't going to be open about a lot of, if they have any issues about red brick or something, they're not going to be open about that, because they're subject to a lot of scrutiny in this process as well. So again, just be careful about that. Yes?
Yeah, Thomas said it, don't talk to the appraising,
That's a
just
good
ask
thing.
the questions, because I say, don't try to oversell it, we don't.
Perfect, and that's good. She's giving good advice to her sellers, and that's what you have to prompt them for. We had a seller who was at the inspection and was really interfering. Everything the inspector said, and he was speaking to the buyers who hired him or something like that, that seller just butted right in, and we had to call the broker and the listing agent and say, could you please ask them to be removed, otherwise we're going to ask them to pay the fee for the inspector to come back. And they said, it's my house. Yes, but in paragraph 7A, you allowed that to happen. And that means uninterfered with and the buyers being unencumbered. Real quick about this paragraph 7, just so you understand about access to the property. If you are driving these buyers around for 3 weeks or 4 weeks, you really know them quite a bit. You've maybe been under contract with them on others and they terminate. If they mention to you that they plan on bringing an entourage of people through this property, they're contractors, they're decorators, you know what I'm saying? You kind of hear that. Just make sure from the very beginning that the seller agrees to that. We've had more disputes in the past year where sellers got fed up that the buyer wanted access to the property, bringing all these different people. They weren't inspectors, they were contractors and decorators, and it just resulted in the seller being very upset, okay? So if you hear that you know the buyers are gonna wanna do that, you're probably gonna tell the buyer, look, I'm gonna visit with the listing agent, let them ask the seller, well, we may have to add it to the contract if the seller gives permission for you to have X number of inspectors, that, not inspectors, but decorator contractors come through the property during the option period. Whatever it's gonna take so that the seller and buyer agree. Because, we have had a lot of instances where the buyers feel they don't have to ask the seller, and that is a mistake. That is the seller's home. They have to have access. Anytime a buyer agent needs to take the buyers under contract to the property, you have to call the listing agent and tell them who's gonna be there, how long they're gonna be there, the truck inspector, the termite inspector. If they have an entourage of various parties, the seller takes great liability in allowing all these people coming on their property. In the listing agreement, it's very clear. In the event we don't cause it as the broker, they'll indemnify us. If they don't give permission or don't know, they're gonna nail the listing broker and agent. Because that is your job. Nobody comes on that property under contract without you knowing who they are. And that's the problem, is there's great liability for a seller to let all these people come on. Case in point, Uncle Joe came along. The inspector was inspecting the property. The buyers were with the inspector, and Uncle Joe went out into the garage and he pulled down the attic access. He gets up there, the next thing you know, Uncle Joe's leg is dangling through the sheet. And the buyer agent is horrified. They call me and they get Uncle Joe out of the mess and bring him down and all this kind of stuff. Turns out, he kept saying, oh, I'm so sorry, everything's fine, blah, blah, I'm so sorry, I'll repair the damage, all this kind of stuff. I said, call the listing agent immediately and notify the sellers. Turns out, Uncle Joe decided to go to the emergency room later that night. And he's asking the sellers to pay for him. And the sellers said to the listing broker, why didn't you tell me Uncle Joe was coming on the property? I didn't agree to him coming. He's not an inspector or somebody that's licensed to be inspected. So just remember, you need to be making sure that that's all taken care of. An email will work. Is it okay if, they bring their grandparents and all this? You're just gonna advise them, yes, they can have no access to the attic during that time. And, you know what I'm saying? Those pull down things have caused us more trouble. They really have. Yes?
I have a question. As a listing agent, when they do the inspection, shouldn't they give you a time frame when they're going to come? Because I had an incident to where they just drove up. The listing agent, the buyer's agent didn't tell us, there wasn't any communication. I've never had this happen before, but I did talk to the other agent and tell them that they need to talk to their inspector, because they walked to the property and they knocked on the door. The mother was out. The father was asleep and the little girl opened the door.
No,
So-
they did not have access to the property. They had no
didn't
permission
tell
to
us.
be on the
Yeah.
property.
And we were under contract, but they didn't let us know in
Yeah,
advance.
they had
they
no
were coming.
permission to be on the property, just because you're under contract, that's why I was trying to let you know, that is not appropriate. At that point, you would tell the sellers, don't open the door to anybody. If I haven't arranged an appointment that you're aware of, don't open the door to anybody. We've had people killed.
Wow.
So that's why you have to tell the sellers, you don't open the door to anyone. If they have an appointment to be there, they'll go through us. We have a truck complaint and a TAR complaint for a listing agent who the neighbor was a great nosy neighbor. You know how you have some of those and they kind of watch? The property was vacant. They called the listing agent and said, is so-and-so supposed to, there are a bunch of cars outside and trucks. Are you supposed to have anybody there? The sellers told me that they have a contract. He goes, no, I'm at the office, but I'll be there right then. He goes over, and they had no permission to be in there. And the buyer went up and got in his face and said, it's a vacant house. We can be here anytime. And then they filed a truck complaint and a TAR complaint against the listing agent for interfering in their inspection. He was exonerated from the truck complaint because it was pretty ridiculous, because this is what they were blaming him for, interfering in their inspection when they weren't even on the property with permission. But the TAR one, they said he violated the code of ethics. So ethics complaints are really serious, and we don't have to resolve from it yet on something like that. Yes.
What happens if they change after the executed contract, they change from like a conventional to a different kind of?
Normally, there's an amendment done. The lender, she's asking about if there's a change of financing. The lenders typically need in their contract showing the type of financing and the terms. Our addendum is a contingency for the buyer to be able to provide notice to the seller as well as property approval. So if they're gonna change the terms, meaning, or they're gonna change the mode of financing, if the addendum is no longer applicable for individual approval, then they will not be able to have that provision. They would just notify them in an amendment about the type of financing. There would be no provisions afforded them through that amendment. You have to be very careful. The moment those number of days passes in the third-party financing addendum, the buyer doesn't have the ability to notify the seller that they're terminating and getting their earnest money. But all material facts about the contract need to be conveyed, and you do that in the form of the amendment. That's how all parties agree to it.
What's kind of a standard number of days for the third-party financing addendum?
There is no such thing as standard number of days. What happens is typically the buyer will find out from the lender, how long is it going to take you to approve me? And if the lender says 10 days, you understand that they're talking business days, not calendar days. And so you could ask for that based on the calendar number of days. The buyer has to understand that you're negotiating with the seller. The seller could come back and say 2 days, and then you'd have to make a decision, accept it or not. There is no standard. The agent that got the fine, that's a permanent record and very bad on track, she told the buyer that it was standard to put so many days in that third party. And Treg admonished her because there is no such thing. It's fill in the blank.
So it's based on the lenders.
The lender's gonna advise the buyer, and then you're gonna tell the buyer, what would you like to ask the seller? The seller could come back and say yes or no. Okay, it's negotiable. But just make sure, put it more on the lender, because they're the ones who are gonna know, how long will it take me to do this, based on what I've gotten from the buyer already, can I give them an approval process pretty fast?
On page 9, the license supervisor associate, is that Michael or is that Veronica?
Most of the ones I see is Veronica. She is the licensed supervisor. Michael is the designated broker for Keller Williams Realty Professionals. And there is a license number for the brokerage entity. But your designated supervisor is Veronica, and she'll have to give you the license number to do that. Yes.
On the lease back of the sellers, this is weird, and I was like, it doesn't make sense. On the lease back, you cover the whole entire house, there's no leasing only the garage or 1 bedroom, right? I'm like, okay, it makes sense, but the buyer agent was in the house talking to the seller, and I was not present as the leasing agent. And they were leasing back the garage, so she can leave her stuff there for another week. And so we're trying to figure out these papers. And I'm like, I know you were coming today. So I called him and said, I don't think so. I was thinking, maybe the whole house or not.
How dare that buyer agent speak directly to your client? That's a violation of the code of ethics.
And so the buyer was there with the seller, and I said, I know it's negotiation between both of you, but I said,
No,
with this.
they have representatives. That does not give them the authority to speak directly to your principal, your seller. Not at all. That is a violation of the code of ethics. Plain and simple. So don't, we have boundaries. We have to abide by them. So, yeah, no, that's a
Yeah, and my seller said, go ahead and do the lease back 1 week. And I'm like.
Now, if they're residing in the property, they cannot lease back just their garage. No, can't do it.
Okay, it's more of a story than what to know.
More of the story. Oh, I'm sure there always is. I have such great fodder for my story. Yes, sir.
What about on the lease back if like the patio roof goes off? Cause that just happened, we did like a 2-week lease back, but she's still in the property.
Is it the seller still there?
Yeah, the seller.
The seller has to fix that and make it perfect.
Okay.
Unless it is.
You're just saying it's not my house anymore, sure, it's their
Right.
body.
Right. these temporary leases are dangerous, and I'll tell you why. Trek didn't like any of these, and the reason they didn't like them is they don't want somebody to be in the property before they buy it, because now they're gonna find all these things wrong, and you know, they're gonna, but a seller to stay in it, the seller has said, hey, anything that goes wrong here on this property, I'm responsible for. And they did that because they don't like the element that a buyer bought the property, closed and funded, but doesn't have possession of the property. So the seller has to turn that property over as a tenant perfectly, pay for everything in it. If it is a casualty loss that will come under the landlord's homeowner's policy, say the wind blew it off, that may be an issue where the landlord's gonna say, you need to pay this much money in my deductible and do that, or you're gonna have to pay for it all. It's not caused by the tenant, but neither is the dishwasher breaking down, and the tenant's responsible for that. We've had a tenant have to, a seller who's now a tenant, had to replace the HVAC system. It went out. And a dishwasher. That's why no seller would ever agree to it if they read it, because it says they have to make the property the same condition it was at time of contract. And they're thinking they're just a tenant. Oh no, that's not what it says. And that's the reason for that. They don't want the tenant, the previous seller, to turn the property over to the landlord and the buyer in a shape that isn't perfect. That was kind of how they discouraged it, so they added that into the temporary lease. Yes?
The worksheet prior to offer, isn't the lender supposed to fill that out before you actually get to write the contract?
That's what you give to the buyer and say, you and the lender need to get together so that we can have these responses, so you can submit an offer that would be acceptable and enforceable so that the lender can perform. Yeah. If they don't do it, it's voluntary, but it does reveal to your buyer that you provided them the framework for them to be able to capture this information. And if their lender won't help them, I think it kind of says this might not be the lender for you.
Yeah, because the lender told me she couldn't, because she has to have a property address first before she could fill that out.
Well, and she didn't understand that most of those questions are talking about based on what they know already, the assets, the income and that from the buyer and stuff like that. So again, you know, it takes it away from you being the one that said, I didn't answer all these questions, to the lender, who that is their responsibility and role. Well, I want to thank you people very much. You know, I know some of you have disappeared, but I want to take this time to let you know how much I appreciate you.